Please, your Lords, Lordships and Milady. 4 points arising out of this morning, if I may. First of all, I was asked...
You on Parry Jones? Have you finished with Parry Jones?
No, we will come back to Parry Jones, the fourth point. It's a segue back into where we were. As to the first point, is I was asked this morning where the authorities that mark the turning point of privilege becoming a substantive right, not just a rule of evidence. And the answer is it's in Derby Justices. And for your note, it's 507. To save you turning to it, I just read you the short line. It's at 507 between D and E. And the bundle reference is Volume 1, Tab 18. Legal professional privilege is thus much more than an ordinary rule of evidence, limited in its application to the facts of a particular case. It is a fundamental condition on which the administration of justice as a whole rests. The second point is, I was asked whether Lord Sumption, in his review of the law in Prudential, returned to deal with the dictum in Morgan Grenfell. I said no, and we've checked, and the answer no stands. He did not. Thirdly, my Lord, the Master of the Rolls, asked me, or put to me a proposition that perhaps in the real world, clients don't ask and solicitors don't say if I'm investigated by a regulator, etc., etc. And therefore, derived from that, it might be perfectly clear and certain what the position is and can be explained if necessary, without being in any sense offensive to the position in privilege. This is something which Lord Sumption dealt with in Prudential. Could I trouble you to turn, please, to Bundle 3, Divider 33. And to come, please, to paragraph 118, which is on page 744. As this may illuminate the answer to my Lord's question, better than anything coming from me. Doubts have sometimes been expressed about how important the assurance of absolute confidentiality really is to clients who consult legal advisors, particularly when they do so in civil or non-contentious matters. How often these doubts are justified is impossible to say. We can assume that they sometimes, perhaps often, are. As Lord Scott pointed out in Three Rivers, obviously true that in very many cases clients would have no inhibitions in providing their lawyers with all the facts and information that the lawyers might need, whether or not there were absolute assurance of non-disclosure that the present law of privilege provides. And then Lord Sumption continues, it does not matter for two reasons. The first is that the law is that the confidence must be protected if proper legal advice is to be obtained. It has been established in this sense for many years, and no one is asking us to depart from it. The second, which is perhaps more satisfying, is that it would be wrong to depart from it in any event. The underlying principle is that those clients who do wish to consult a lawyer on the basis of absolute confidence should be entitled to do so, notwithstanding that absolute confidence may be less important to others. And the last of the 4 points in this morning concerns Parry Jones. If I could trouble my Lords, I'm sorry about hopping from bundle to bundle, but to go back to Bundle 1, Tab 10. And if I could make 2 points, please. The first is, as was put to me, if I may say so quite rightly, by my Lord Justice Lewison, that the focus in Parry Jones was upon the accounts under the accounts rules. But if I may say so with respect, it wasn't limited to that. As one sees on page 162 in the head note, 5th line, requiring him to produce for inspection his books of account and any other necessary documents. It's a small point, but I just thought it right to invite my Lord's attention to that. And that is a point that is repeated on 163 between F and G. So any other necessary documents relating to A, his practice as a solicitor, and B, every trust of which he was a trustee.
Yes, what they were asking about were his accounts.
Yes. Yes. I did not disagreeing at all, as I hope I made perfectly plain, but I just thought I'd just bring that small adjustment to your attention. But perhaps more importantly, my Lord put to me that the case was, on one view, not about privilege at all, but about confidentiality. And I accepted that that is one basis of looking at it, and I don't depart from that. And I also said that whether for that reason or because the law of privilege has so significantly changed, it's a case of no authority. I just wanted to remind my lords, my lady, that in the court below, we put a note in for the judge, which I don't require or invite the court to turn to, which is in your supplementary bundle, tab 9A. I'll merely give you the reference, in which we analysed the language used in Parry Jones, because whether it was a period piece or what it is, the language of privilege and confidentiality were used interchangeably. And if you wish to see an analysis of that, which I do not wish to delay you with now orally, it's from paragraph 17 onwards in that note, which begins on page 142, stop 4.
Yeah.
Now,
if you look at the grounds of appeal on page 4 of the report, G,
yes,
privilege because subject to an obligation of confidence, which is what the way that Mr. Parry Jones argued it, and Mr. Bingham for the Law Society, page 5, letter F, poses the question: does the power of investigation override the implied contractual confidence?
yes,
So that's the way the case is argued.
yes. Indeed. I've not disagreed with my lord at all, but it is interesting to look at the language, or it may be. I mean, it's not going to be dispositive of this appeal, that's for sure, but it's a small point. Now, my lords, my lady, having considered the position that we'd reached over the short adjournment, of the cases upon which the learned judge relied, the only one which we on reflection think is worth taking your time by looking at in this hearing now is McKee. I've given you our one-line response on all of the other authorities already, and going back over them in greater detail won't illuminate the point.
Well, I wonder if you could just spare a moment for Taylor.
Yes, of course.
Now, Taylor was one of the cases referred to in Morgan Grenfell.
Yes.
And I noticed, looking at the judgments of the Divisional Court and the Court of Appeal in Morgan Grenfell, both those courts thought that Taylor was irreconcilable with the outcome for which Morgan Grenfell were arguing. Now, we know that the outcome for which Morgan Grenfell were arguing ultimately succeeded in the House of Lords. So what do we make of the observations both in the Divisional Court and the Court of Appeal that outcome and Taylor were irreconcilable?
I think what we make of them is this. Firstly, that a reconciliation was found, but secondly, the reasoning, the ratio, as expressed, was disapproved of by Lord Hoffman in Morgan Grenfell. May I take you to McKee, please, which is volume 2 of the authorities, tab 29. This, as you know, is a decision of the House of Lords concerned with covert surveillance of prisoners in Northern Ireland. And so very different to where we are now. But as you'll have seen in the authoritative text written by Mr Passmore, a line is rightly drawn by him between the technical infringement cases through to the situation that we have reflected in McKee. You may look at that later. But it is useful, in our respective submission, to focus, because otherwise it can be misunderstood, on what is meant in paragraph 10 of the, in the speech of Lord Phillips, which is page 588. Here he does consider the dicta of Lord Hoffman in Morgan Grenfell. You can see that above. He sets out paragraph 32 in full. And then he says this in paragraph 10, the editors of Phipson on Evidence observe at paragraphs given that this is a novel approach to privilege and express the hope that it would not be followed. I pause there just to remind my lords that the same theme runs through in Phipson in its current edition, as it does in Hollander, as it does in Passmore. Although it is right to also note that the editor of the author of the chapter on this in Phipson is Mr Hollander, so any similarity is perhaps
consistent.
entirely so. It'd be disappointing were it otherwise. I think some words are changed for copyright reasons, but other than that, there are remarkable similarities in the chapters. But that said, but then Lord Phillips goes on, for myself, I find that Lord Hoffman's approach illuminates the issues that arise in the present case. I'll come back to that. The rationale underlying LPP is the fundamental requirement that a man should not be inhibited in speaking freely and frankly to his lawyer by concern that what he says may subsequently be disclosed to his prejudice. This appeal involves the tension between the importance of covert surveillance in the fight against terrorism and serious crime and the importance of LPP. In this context, it is necessary to consider not merely whether and in what circumstances surveillance of communication subject to LPP should be permitted, but the use that should be permitted of communications subject to LPP that are disclosed by that surveillance. This is a topic to which I shall return at the end of this opinion. And then if one comes on, I'm sorry, this was not sidelined for the court, I apologise, but it struck me it might be helpful nonetheless. Look at paragraph 45 on page 596. The rationale for LPP is not that it is in the interests of justice in the individual case that what has passed between the lawyer and his client should not be made public and where appropriate admitted in evidence. Often it would be in the interests of justice in the individual case that this should occur. See, for example, the facts of Derby Magistrates Court. The rationale for LPP is that it is necessary if clients are not to be inhibited from being frank with their lawyers. As Lord Hoffman pointed out in Morgan Grenfell, the concern that may inhibit frank communication by a client to his lawyer is not so much that the matter communicated may be disclosed, but that the matter may then be used to the detriment of the client. And then this, if regulations are to be made that authorise surveillance that may disclose communications which are subject to LPP, those regulations must address not merely the circumstances in which such surveillance is to be authorised, but by whom, but also the use that may be made of such communications if disclosed. To a degree, the Code attempts to do this, but it does so in a manner that lacks coherence. And then Lord Phillips goes on to set out observations relevant to the Code. So the manner in which his lordship finds the dicta in Morgan Grenfell helpful is in illuminating the focus upon use in the context of statutory regime permitting an override. And it doesn't mean any more than that. And so to read it as meaning, when he says, in paragraph 10, for myself I find that Lord Hoffman's approach illuminates the issues that arise in the present case as standing for anything more than that, such as an approval, would be to over-read the words.
Were they, in McE, there was no question but that what was overheard might well be used adverse to the prisoner. That presumably was the point of it.
Yes.
So they can't have been, it seems to me, relying in any way on the new exception in the dictum if that exception has as one of its conditions for application that there's no risk of the information being used to the detriment of the person who holds the privilege.
Absolutely right, if I may say so. Absolutely right. And so this passage, which hitherto might have been freighted with a greater significance or weight, can't bear it, for the reason that my lady gives, plus also the explanation when one looks at paragraph 45.
One of the other points about Lord Phillips is he's saying that if you're going to override LPB, it's the regulations that want to do it.
Yes.
It's not a common law exception.
No. Exactly. So, my lords, my lady, with that, I'm going to leave the authorities that the learned judge relied upon. And I'm going to come now to deal with ground 3, which I will do with real economy, I hope, because as is always the way, as one travels through an appeal, so much of that the one would otherwise say has now been said. So I shall deal with this, I hope, shortly. This deals, of course, with the alternative aspect of the Morgan Grenfell decision, the second aspect of the dictum, the idea of a technical infringement. You have seen how the concept of technical infringement arose in the speech of Lord Hoffman in Morgan Grenfell. I'm not going to take you back to it again. But the notion that any infringement that is only technical and therefore authorised by the Law Society powers arises from the passage in its proper context. So it is worth unpacking that. Although I suggest that this analysis is essentially parasitic on the no infringement reasoning and ultimately falls down for the same reasons. So there are 4 points, if I may, and I shall make them shortly and then move on. We have not, in preparation for the hearing before the learned judge or for this appeal, been able to find a single instance that supports the proposition that there should be gradations of infringement of privilege. That is not surprising, because if one takes the position, as we say English law does, that privilege is the right to object to any third party for any purpose seeking the communication, unless the client agrees to waive, it's hard to see how there can be a concept of gradations in infringement. Either it is kept private, or without the client's consent, or it is not. It is binary.
Right.
So this
What are we considering here? Are we considering an exception at common law for a technical infringement? Because that's not where Lord Hoffman put it. And Lord Hoffman said, or to the extent that it technically did, i.e. breach levy, it was authorised by the Law Society's statutory powers.
Yes.
He doesn't describe it there, as it were, a standalone exception apart from any statutory authorisation.
Well, the way in which we have read it, as I said right at the start, is these are two sides of the same coin. What one has on the front side of the coin, infringement, the no infringement principle, the first limb of Lord Hoffman's reasoning, and the second is, after the or, if it technically did.
I'm just saying, if you read the sentence, in my opinion, this limited disclosure did not breach the client's LBB. We've dealt with that.
Yes.
And that is, or, to the extent that it technically did, was authorised by the Law Society's statutory powers.
Yes.
So So all I'm saying is, if you read that sentence as it's written, so it seems to me, he's saying, well, insofar as it was authorised. I mean, the technical bit is neither here nor there, but it's really that it was authorised. It was either, he puts it as either there was no breach of the LPP, or it was authorised by statute. There's not kind of an intermediate position,
Well,
so far as I can see.
um,
Or have I misread it?
well, no, with respect, I would submit that you may have done. In the way we read it is this. In my opinion, this limited disclosure of the sort which we're talking about here did not breach the client's LPP. So pausing there, no, we've dealt with exactly ground one, no breach. Or, and I'm going to add in the words, in the alternative, and to the extent that it technically did, so technically did breach the LPP of the client, it was authorised by the Law Society's statutory powers. So they do seem to us, with respect, to be two alternative ways of addressing the issue. Either no breach of LPP at all, or if there was some technical breach of LPP, the statutory powers authorised it.
Yes, I think I'm agreeing with that.
Okay.
Well, is he then saying that when you are undertaking the exercise of construing the legislation to see whether there is an implied override, assuming there's no express override, of LPP, you might imply into the legislation an override of LPP only for technical breaches, by which he seems to mean breaches where A, there's no risk of adverse effect on the right holder, and B, where the recipient of the information is going to be bound by duties of confidentiality not to pass it on. Because I suppose if you're implying an override into a statute, you can imply it to whatever extent you want. I don't know. It seems to me that's how I read it. That he was saying that you don't have to imply into the legislation a complete override in all circumstances, that privilege is no longer to be considered at all, but a more limited override. I mean, what basis there is for that, I can see you consider, but that's, if that's any help to anyone.
Well, it certainly is, because, and that's why it is, if I may say so, offensive, because you have this solid position of, if not express, necessary implication, for which the structure is a very high bar, and it must be, and I hope I have the words correctly from Lord Hophouse, it's a matter of express words and logic. As he puts it at the end of his speech in Derby Justices, when talking about this, and that is what you're looking for. But here we have this variation upon that theme, which I called before authorization light, by which it is accepted, I think, by the respondents to the appeal. It is accepted that there's nothing here that would meet the high bar set by all the authorities on necessary implication. And I remember the quotation tolerably accurately. The necessary implication is a matter of express language and logic, not interpretation. And that's Lord Hophouse in paragraph 45 of Morgan Grenfell, page 369.
So, I mean, is the proposition, we won't know until we hear Mr Justice, you've got to find something, if we're not looking for a common law exception, because we're no longer dealing with a common law exception, we're looking for some sort of statutory, or using the word of Lord Hoffman, a statutory authorisation. Talk about authorised by the Law Society's statutory power. So you're looking for a statutory authorisation of something. And as I understand what you said in your discussion, my lady, is that you're dealing with this on the basis that the argument is, on the other side, that you don't need to, for a technical incursion of LPP, you don't need to meet the full requirements of necessary implication.
Yes, that's what they're
You
saying.
only need to meet something less, but what is the less?
Well, precisely. But that is, my lord, captures exactly what Mr Simpson and the FRC are saying. That is precisely what they're saying. But the question that my lord puts is, if I may say so, a thoroughly good one. And we say that therein lies the vice of the approach. What is the less? If I can restate back to the court with respect to the question. And I know
I can't remember what in this particular case. You have to remind me. Was the Law Society statutory powers, did that meet the necessary implication?
So I just understand I'm not being even more stupid than usual. Which
No, but when he
case?
says in that particular case it was authorisation by the Law Society statutory powers, I can't recall what particular statutory power he's referring to there.
I think Lord Hoffman is referring to the then extant version of the Solicitors Act, which I think the Solicitors Act
Which
1947.
expressly dealt with this.
I think so.
It didn't refer to any particular statute.
No, he didn't. But it must.
The Harry Jones doesn't either, but it does. It quotes. There is a quotation from section 29 of the Solicitors Act, which gives the council the law society power to make rules by the counts. To take such action as may be necessary to enable them to ascertain whether or not the rules are being complied with.
Yeah, section 29 is in tab 1 of volume 1 of the authorities. But it doesn't improve upon what my lord has just said.
So I'm just trying to understand what again is meant in this phrase, authorised by the Law Society statutory powers. And there's no other explanation of what that might be.
No, there isn't. But I think, subject to correction, of course, as always, that what it must be referring to is section 29C of the 1957 Act, which is the applicable.
It seems to be, if you look at the bottom of page 167, the actual power is the rule in the Solicitor's Accounts Rule, which empowers the council in order to ascertain whether these rules have been complied with. The council may require any solicitor to produce his books and so forth. At the top of 168 of Parry.
Yes, I have it.
So that was the power, that it had the power in order to ascertain whether these rules have been complied with, that's the accounts rules, to require any solicitor to produce his books and so forth.
Now, and those rules, of course, are made pursuant to statutory powers. So that one would say,
Yes.
you would say, presumably, that was a case of, didn't need necessary implication, that was a case of an express right, because the statute conferred the power to create the regulation, and the regulation said they've got to be produced.
There's a fuller quotation of the regulation on page 162, footnote 2.
You would still have to.
May require any solicitor to produce basically fix all books of account, bank passbooks, loose leaf, bank statements, statements of account, vouchers and documents.
But
Then it goes on to say such report may be used as a basis of proceedings under the Solicitors Act.
and the rules are made treated as if having been made under section 29 of the 1957 Act, because it says so, as you've seen.
I'm just trying to, I'm neither
So
trying
what-
to help you
yes.
nor hinder you. I'm just trying to understand because we're still going back to the same two sentences, or
Yes.
one sentence. But, I mean, if it be the case, and you haven't so far put it like this at the moment, but if it be the case that the Law Society's statutory powers in question in this case were actually either expressly or by necessary implication covering this, we don't, I mean, he doesn't even deal with the question of a lesser standard.
No,
So that's why I was asking the question.
no, I understand. And if there is nothing, there's no problem, if I can put it in that way, with any of this if there is a statutory override.
Right.
And therefore, if the Solicitors Act 1957, Section 29, 1C, combined with the Solicitors' Accounts Rules, in combination either expressly or by obvious necessary implication, confer a power, there's no problem.
Well, if they confer an override.
Yes, yeah, that's what I mean by power, yes, an override, yes, exactly.
So I'm just trying to understand where you are, where your case is on this. Is it your case? It's quite important, I think, to me. Is it your case that that Lord Hoffman's reference to authorisation of the law society statutory powers was, on the facts of that case, a reference to a statutory provision through the regulations, which was either expressly or by necessary implication a reduction, if I can put it like that, or a curtailment of LPP. Is that your case?
That must be what he's meaning. But that is an adherence to the orthodoxy and not the creation of anything different.
Well,
no, that's the point.
sorry, do you accept that that if you are looking to imply an override into a regime which empowers a regulator to call for documents, you could imply something short of a complete override which ignores any privilege at all, if you thought that some lesser override would do the job. I mean, I accept that you would say whenever you're implying an override you have to meet the high hurdle that Lord Hobhouse
Yes.
referred to. But if you might meet that high hurdle for a more limited override than you would for a complete override, if you understand. Is that a possible outcome?
Well, I can see how one can construct that in the abstract, but how does it really work? I'd respectfully respond.
Well, can I also raise, just going back to page, I'm now at Morgan Grenfell again,
Yes.
bottom of page 611. She says, the reasoning in the Parry-Jones case suggests that any statutory obligation to disclose documents will be construed as overriding the duty of confidence which constitutes the client's own protection. So that's how he explains it, I think, and it goes on to say, in the present case, it is accepted that the client is protected by LPP and that this cannot be overridden by primary legislation containing express words or necessary implication.
Yes.
So it seems difficult to say then when he's dealing with 32 that he's saying, well, notwithstanding what the parties accept, that you can only be overridden by primary legislation. I'm saying something different. It would be a very odd thing for him to say.
Yes. All he's saying at the foot of page 611 is he's reciting the reasoning in the Parry-Jones case and what it suggests to him.
Yes. I was making a slightly different point.
I see.
It's really the next sentence. He says it's accepted, in his case, Morgan Grenfell, it's accepted that the client's LPP can be overridden only by primary legislation containing express words or necessary implication. Well, since that was accepted, when he comes to 32, he can't be deviating from that. That's what I would have thought you would. Is that your case? It seems to me that it would be very odd for him to say it could be something less than that when the parties themselves have accepted that it's only by express words or necessary implication. That's what I'm suggesting to you.
Which is, as an analysis, if I may say so, fine insofar as it goes in this case, because it is an adherence to the orthodoxy.
Quite.
Yes.
So what I'm suggesting is I thought it might be your case, but we haven't heard of this. At the moment, it seems to me that it would be very odd, certainly counterintuitive, for us to read what he says in 32 as suggesting that anything other than primary legislating containing express words or necessary implication can override because he said in the 2 paragraphs before them, well, it's accepted in his case. That's the only way in which you can override it.
Yes.
And therefore, that would tend to undermine the suggestion that he's saying that a mere so-called, inverted commas, technical breach can be overridden by something less. So
Which is entirely consistent with our position on the appeal overall.
but I don't want to give you a bad argument.
No.
That's what it seems to me at the moment.
Well, may I adopt the argument and say that in the alternative, if, which is contrary to the position that my Lord put to me, in fact what he's purporting to do is to create some lesser hurdle. Technical infringement equals technical authorization, a little bit of infringement, a little bit of authorization. That would not be acceptable, would be bad law. So I think that we can have it either way, if I can put it in. Thank you very much. I don't think repetition of any of the points that I was minded to make on this ground actually is necessary in light of the extent of this debate. And so I'm going to move, if I may, to ground 2.
Well, what did you get out of McKee then?
Oh, out of McKee, we got only the fact that there is nothing significant for the purposes of the issues in this appeal from Lord Philip saying in paragraph 10 that he himself found the way the matter was.
That it was illuminated.
Exactly,
yes.
exactly.
He wasn't, you say, the illumination was in relation to a different aspect of the paragraph.
Precisely, see paragraph 45. Yes, exactly. It didn't illuminate the rightness of what Lord Hoffman was saying in the context of Morgan Grenfell, let alone in this case. It is an illumination of the point of use when considering the regulations in McKee for terrorists and their legal consultations. So if I can now come to ground 2, all of my submissions so far have been, as you know, directed at arguing the Morgan Grenfell dictum, or the version of it applied by the judge, is not good law. Ground 2 proceeds from a different premise. It proceeds from the premise that even if the dictum is good law and the infringement or technical authorization reasoning is correct, whatever the latter means, then the judge in our case is nevertheless wrong, because the principles could not be applied to the present case for 2 grounded points. 1, the judge was wrong to find that this was a case where there was no infringement or a technical infringement, given that in this case there is a real risk the documents will be used to the detriment of the appellant. And secondly, the judge was, with respect, wrong to find that the Morgan Grenfell dictum could be applied in the specific statutory context at issue here, which is a situation where not only is there no express authorization of an infringement of privilege, or anywhere from which one can deduce the necessary implication, there is actually express protection for privilege, which is rendered effectively nugatory by the judge's application of the Morgan Grenfell dictum.
You say there's a statutory override in the opposite way?
I do. I say it would be extraordinary if you can override something where the statute actually rides the other way. I have to deal with those 2 points separately, and I do, but I do so not, I hope, at undue length.
Can you just remind me
Yes.
of these documents, which are privileged, arguably, relate to some litigation separate from the matter that's being investigated by the FRC? Is that all?
Yes. The background, in brief, the short answer is yes.
Yeah.
And the background is this, that the central issue was the treatment in the statutory accounts of the trading relationship between Sports Direct and a company called Barlin, the chief executive of which was John Ashley, Mike Ashley's brother, Mike Ashley being known to the court, obviously. And it is said by the FRC in the context of this case, that should have been disclosed in the accounts. Separately, exactly as my lady says, separately, there were investigations in at least 3 other countries, being Finland, France and Ireland from memory. And I think also, in fact, Belgium, but certainly 3, into the distance selling arrangements and the treatment of VAT. And the legal advice contained is referable to those other related proceedings and investigations.
Right,
And
but it's accepted that the request, the notice, would on its terms cover these documents in whosever hands they are, even though they deal with a separate matter.
Yes.
That's what's so puzzling.
Yes, we haven't actually looked at the notice at all. Would you like us just to look at it?
No, just summarise.
Yes. I mean, yes, they are, it's a call for materials that concerns the scheduled issues passing between the scheduled custodians and must therefore be covering the same ground, at least in part. There would be an overlap, if not a complete fit. There may be a correction coming on my factual synopsis. May I just take it now, just in case? So can I just clarify, thank you very much, just clarify one small point. The documents that are, we're concerned with here are not all necessarily derived from or related to that litigation. It may or may not be. As long as they were caught within the round of being responsive to the criteria set out in the notice itself. And so not all of them necessarily are, as it were, hitched to the foreign litigation that was going on or any work relating to that.
Right, but the documents about which this dispute is taking place are, as I understand it, emails between whom and whom?
They're emails between the lawyers, RPC, and Sports Direct or its subsidiary.
But they are in the hands of Grant Thornton, or...
No, they're not. They're in our hands.
Right, yes, you're the public
yes,
interest
yes,
you're
yes.
the public interest entity.
No, SDI. Thank you very much. Too closely identified with one's own client. It may be easier if I show you those in supplementary bundle. One, but then friend's trying to show me a piece of paper at the same time.
It's the same.
Okay, thank you. If we turn to the supplementary bundle, tab 1. Thank you. You'll see that the information and cooperation required is 1, for the purpose of the investigation pursuant to rule given, I require you to provide me in electronic format all emails and attachments to emails in the possession and control of SDI satisfying all of the following criteria. And then they set out the criteria. And then you will see the criteria makes references in B, held by one or more of the custodians in Schedule 1, which is page 4, identifies the 5 custodians.
And those are all SDI people, are they?
Yes, they are. C, dated within one of the date ranges in Schedule 2, dates given, responsive to one or more of the search terms in Schedule 3, page 6. And the search terms include, as you will have seen, for example, at 2, Barlin, 8, Grant Thornton, 12, John Ashley, and so forth.
Right. So when SDI performed those searches, what came up included emails between them and their lawyers.
Yes?
And it's those which they are seeking to
Yes.
withhold.
Correct. So I was dealing with the first part of the argument on prejudice and why under ground 2 the principle incorrect can't apply. And I'm going to invite you to look at it through, if I may, 3 different lenses. The first is through the AEP, Audit Enforcement Protection Investigation. Secondly, through the Accountancy Scheme Investigation. Thirdly, and I promise very briefly, through something which is a late arrival in this case, post the hearing in front of Lord Justice Arnold, something called the Corporate Reporting Review, or CRR, which is been raised in circumstances I shall explain. Insofar as the AEP investigation is concerned, for the present purpose, we invite you to assume against us, against the appellant, which is in fact a false assumption, as I shall explain, but assume the FRC is only using the material for the purpose of the AEP investigation into our former auditors, Grant Thornton. If that is the case, the question that bites is as follows: is it right that the documents are not being used against the appellant? And we submit the answer is no. It is, with respect, another aspect of the judge's decision that would benefit from focus, that despite a purporting to apply the Morgan-Grenfell dictum, the judge did not directly address the critical question as to whether the use to which the FRC want to put the documents prejudiced SDI, notwithstanding that the lack of use against the party is supposedly a central tenet of the dictum. As we have seen, the judge seemed to think from his judgment, see paragraph 84 and elsewhere, that there was some special rule for regulators, and that he needed to know, all he needed to know, was that SDI, the appellant, was not the subject of the investigation. But, with respect, that doesn't begin to address the issue. The central tenet of the dictum was that the information was not being used against the person entitled to the privilege, and we've read this many times. So one does need to consider, in our respectful submission, whether it is being so used. And we submit that the position taken by the FRC on this is unrealistic. Firstly, this case is nothing like Parry Jones or Sims, where the investigation into the solicitors could have no conceivable impact on the clients. To say the documents are not being used against Sports Direct International under the AEP investigation is just not realistic, because what the auditors are being investigated for is for failing to stop SDI from doing something, or failing to ensure that they did something in their accounts. To say it's not being used against SDI is a triumph of form over substance. in our submission, and yet privilege to a substantive human right of real substance is what's at stake. Moreover, the FRC perfectly properly, in their skeleton argument, emphasise that some of the means available to the SRA when dealing with solicitors to protect the clients in the context standing in the shoes of the appellant are not in practice available to the FRC. For example, it is accepted by the FRC that one of the things which the SRA does to protect the client's privilege is it anonymises the client. So the identity of the client whose privileged material has been obtained is not released. But that is not something which, it seems to us from reading Learned Friend's skeleton argument, paragraph 45 in particular, can realistically be done by the FRC. They say, with some understatement, that it may well be more difficult, in other words, to anonymise the client than it is for the SRA. But then they go on to say that the court can be reassured because any reputational damage is, in their words, indirect. Well, indirect is damage nonetheless, and 45.2 of Learned Friend's skeleton repays careful reading. Even if we assume the no infringement principle is good law, then one can see how it works when the identity of the client is kept confidential, where there is no risk even of reputational damage because no one knows who the client is, but that is not the case here. And it is simply, in our submission, not good enough for the FRC to just say, oh, well, it's only indirect, so don't worry too much about it, or words to that effect. It just goes to show how different is the present case from the solicitor's context, which we've been looking at in some of the other cases. And we have made the point in our skeleton argument, for your reference, paragraph 25, that the appellant as a corporate entity is the subject of quite intense press interest, and that there is a real risk that, assume there was a finding against our former auditors as a result of this investigation, that there would be an adverse effect reputationally, whether or not that is justified. It's interesting to note that the decision of the judge in the court below caused a 5% fall in the share price of the appellant and required the issue of a clarificatory market announcement, as we say in footnote 3 in our skeleton.
Presumably they have disclosed a lot of other information between them and Grant Thornton, between them and Deloitte, which couldn't arguably be covered by privilege.
Yes.
And they can use that, and it's that which may well lead to damage to reputation. I can't quite see what additional damage to reputation would arise from the disclosure of their emails to RPC.
It just depends what the contents are.
But what you're saying is that if Grant Thornton as auditors are criticised for having failed to pick up some potentially misleading item in the balance sheet, whatever, then there's an implied criticism of the internal people for having put it in the balance sheet that ought to have been caught by the independent auditors.
Yeah, absolutely. That is the whole
That's nothing to do with the privilege material.
Well, it might be.
Well, one can certainly think of examples. I mean, suppose SDI had asked RPC, do we need to tell Grant Thornton about this?
Yes.
And RPC said, well, quite difficult, but on balance, I think you probably should. And they didn't.
Yes.
Or they did.
Yes. Exactly. Or if, yes, I needn't go on musing on alternatives, but yes, my lord, indeed, and one can think of other examples as well. And of course, it washes over particularly into my lady's point, if I may say so, when I come to the next head of this submission, which is consider the prejudice through the accountancy scheme. Because of course, in parallel with all that going on over there, and taking exactly as my lady just articulated it, the issue that as regards SDI's own conduct that inevitably arises as the premise for were the auditors at fault, is the very issue that is at the centre of subject B in the accountancy scheme investigation. Because of course the FRC have perfectly properly made no secret of the fact that they are following, if I may put it this way, exactly my lady's lead. And they're not only investigating the auditors, but they're investigating an accountant, subject B, in the employ of the appellant company for corresponding misconduct. Which is why the crossover and the collateral use, if I can call it that, is potentially very important. And it's just that with your leave, I shall now turn. The notices are, as you know, issued under the AEP only. And the FRC has no power to issue equivalent notices under the accountancy scheme. In relation to some other documents handed over already, RPC wrote to the FRC and made clear that the documents were being provided only for the purposes of the AEP investigation and asked the FRC to confirm they would not be used for any other purpose, including the accountancy scheme. If I can invite you, please, for this part of our submissions to have the supplementary bundle. You won't need any authorities bundles for this, helps. And to turn initially in the supplementary bundle to tab 13.
Supplementary or supplemental?
I think it's TAL.
Is this one?
Yes, thank you. Tab 13, please. 16th of July 2018, so just before the hearing. And then on the second page, paragraph 1.3 and 1.4. For the avoidance of any doubt, these documents have been provided in response to the FRC's notice dated the 20th of April 2017, that's the one in issue in this case, which was issued to SDI, etc., etc. We therefore said that the FRC only has the power to use these documents for the purpose of its investigation under the AEP and not for any other purpose, including a separate subject B under the accountancy scheme. If you consider the FRC has the power to use additional documents for any other purpose, we should be grateful if you would explain the rationale for this, and the interim does not consent to additional documents used for any purpose other than the investigation under the AEP. To that there was no actual response. But the FRC made its position clear to the judge. And if one looks at, first of all, at tab 8 in this bundle, please. This is the skeleton argument of the FRC trial. Page 71, please, paragraph 4. Pursuant to its powers under SATCAR and the AEP, the FRC is presently conducting an investigation of the conduct of Grant Thornton, an individual of Grant Thornton, subject A, in relation to the audit of financial statements. So perfectly clear to what the application is hitched. And then if one looks at tab 10 in the transcript, page 178, my friend, with his customary clarity and skill, expressed the position precisely. So between F and G, now my lord, the key point here is the purpose. So the FRC are not entitled to use this information and not intending to use this information, these documents, against Sports Direct. They're being disclosed or would be disclosed for the purposes of the investigation into GT. If they were to be used against Sports Direct, which they could not by this regulator itself, then that would be an infringement of the privilege And so, my Lord, what is said is by analogy with Parry Jones. In fact, either there is no override or there is only a very technical override of LPP because of the purpose for which the information is to be used.
I think he means infringement.
Yes, yes. He does, but bar that, it is very clear. And then over the page, and of course, my Lord, for SATCAR, the FRC is only allowed to use it for certain specified purposes. After the judgment, there was then after the judgment was handed down, there was a debate between the parties about a recital recording the use to which the materials were to be put. And if I could just take you, please, in the core bundle to the order under appeal, which is core bundle tab 7. Sorry, 6, forgive me, 6. 7 is the judgment, I've taken down, sorry, 6, thank you. And the second page of the order, which is page 79, and the second recital, and upon the applicant confirming it will not use any documents provided to it pursuant to paragraphs 1 and 2 of the order, and we're concerned with 2, below, for the purpose of its investigation under the accountancy scheme, without giving subject B and the respondent 28 days notice of its intention to do so, any dispute arising out of this recital will be reserved to the Honourable Mr Justice Arnold. This is something to which I alluded earlier on today. Now, the position is this, that the correspondence, the to and fro between the parties over the terms of this undertaking continued. And as my learned friends note in their skeleton argument for this appeal at 45.4,
It's not an undertaking.
I beg your pardon?
It's not technically an undertaking, it's a confirmation,
It is,
by
yes.
contrast with the undertaking above it.
Sorry, thank you very much, thank you. It is accepted that there is a dispute, as the word they choose to use, between the FRC and the appellant as to their entitlement to use this material under the accountancy scheme, if they get
Where's
it.
that from?
That is from the skeleton argument from learned friends in this appeal,
Oh, I see, yes.
paragraph 45.4. But the problem is that one has to consider the reality of the position, which is brought into sharp relief, if I can take you please, in the supplemental bundle, tab 27.
The confirmation in the order only relates to the small number of additional documents.
Yes.
But presumably they want to be able to use all the documents they've received, and you dispute their entitlement to use all the documents they've received, regardless of whether they're privileged or not, in the accountancy scheme proceedings. Is that right?
All documents they've obtained through SATCAR.
Yes.
Yes.
Because my understanding was that, that in response to the notice, the 20th of April notice, there were documents
Yes, there were.
disclosed.
Yes.
What sort of volume of documents?
I'm sorry, Tony, I don't know readily the answer to this.
Well, I mean, just
About 2,000 documents.
right. So there is also a dispute about, which is not dealt with in this confirmation in the order, about whether those documents can all be used under the accountancy scheme as well.
Whether there's actually a live dispute, I don't know at the moment. I'd have to come back to you and tell you the position tomorrow. I don't want to go and mislead you. But because all this has only happened since the hearing, much of this happened only since the hearing, particularly what I'm about to show you. So it is a matter of dispute, to use the learned friend's word from his skeleton argument. Of that there is no doubt. But this order, exactly as you rightly say, only relates to the privileged material that we're concerned with here, 19 emails, 21 attachments. But interestingly, when one is considering, and this is all under the banner of prejudice, it feels like sometimes a long way from that, but that's what it's all still under the banner of. If I could invite you at tab 27 to page 293, this is in the middle of a letter from the FRC to us of the 14th of November 2019, so long after 18 months, 16 months after the hearing, and 14 months after the judgment. Heading, use of additional documents. Could I invite you please to read, if you kindly would, just paragraph 10 on that page.
What's CRR?
It stands for Corporate Reporting something, and it's yet another stream, Corporate Reporting Review, which is another power that the FRC has to, as regards the appellant directly.
So which paragraph are we reading?
Paragraph 10 on page 293, if you please would, thank you. So,
How would you articulate your point on
Articulate it.
paragraph 10?
paragraph 10 as conveying two things. One, that all this time after the event, we're told that there is a single investigatory team, little a, considering the additional documents, that's the term of art for these documents in this appeal, for potential relevance to both the AEP investigation, permissible, and the accountancy scheme investigation, we say impermissible.
And that they've done this without giving you the 28 days notice?
No,
Or is this giving you 28 days notice?
of an intention to actually apply to use them. So they're considering that the order is 28 days, notice of its intention to do so. This is an exercise at this stage relating to the non-privileged documents, because obviously they haven't got the privileged ones, so they can't be considering them. So this is the additional.
Oh, I see.
See,
Well, wait a minute, I don't consider
Can we, I just
the
getting
additional.
slightly lost here.
It does
We're
refer-
now looking at the situation, we're now looking at the question to the extent to which you might be prejudiced
yes,
if these documents are disclosed.
yes,
Which you say was quite unlike the Morgan Grenfell situation. So that's what we're exploring.
exactly.
There, the disclosure was to a single regulator in relation to a particular matter, we
Yeah.
assume. Your point, as I understand it here, is that this is a much more complicated scenario, if only because, and you're now referring us to this, that the FRC is actually got a single team carrying out two separate investigations.
Yes,
Well, that's the AEP and the AS.
correct.
The AS, one as I understand it, is in relation to a particular employee. This is subject B, who is
Correct.
employed directly by your company.
Correct.
Your concern is that anything relating to that might be disclosed in relation to the accountancy scheme and that man might have implications. Is that right?
Yes, it is part and parcel of the risk, exactly as my Lord has just summarised it, entirely accurately. So we have one additional concern towards the penultimate point of what my Lord just put to me, which is this, that the premise for the application under SATCAR, or application of SATCAR, is to limit, as my learned friend told the judge at the first hearings, to limit the use of the fruits of that investigation solely, to borrow a word, to the AEP investigation. However, in reality, in this case, ground 2 prejudice, first limb, in this case, we've got a single case team that they say on their face are investigating both cases, AEP and AS, and the case team has considered the additional documents, which are the documents produced under SATCAR, non-privileged, but produced under as responsive to the SATCAR notice already, for both cases.
And also, is this right, you have a point about anonymisation here as well. Does that fit into this?
It's at a tangent to this, but it is a further example, because our point there is, in short, the SRA, Solicitors Regulatory Authority, have the ability to anonymise the client in their proceedings.
But here, using the FRC said it may be more difficult.
Correct, exactly so, exactly. And so this is not one of those cases that if all else is against us, if we've lost on grounds 1 and 3, this is not a case for applying that principle, whatever it is, at all, because the exposure is considerable. And so it is impossible to say that where you have a theory that hinges on solely for a specific purpose that doesn't expose the privilege holder to any prejudice, you can't say that that applies here. Can I just deal extremely quickly with the CRR? And I do so with a degree of hesitation. What has happened is best dealt with perhaps by reference in the supplemental bundle to tab 25. This is April 2019, this letter, so some considerable time after the judgment, obviously.
25.
I'm so sorry, supplemental 25. Paragraph 1. In considering SDI's appeal, an issue has come to my attention regarding the FRC's corporate reporting review function, which I consider it appropriate to raise with you in the context of the non-infringement principle. And it then sets out what the function is, and I'm going to have a perhaps hopelessly optimistic go at summarising this point in a sentence. It appears that the FRC have the power to bring some form of enforcement proceedings, if appropriate, against the appellant.
So they can bring it in their own right against you.
Yes.
Directly.
Yes.
Will they say that?
Yes. Yes. They can. I think.
Oh, you accept that?
Yes, I do.
Oh, I see. And what is that? Is that, as my lady I think reverted to earlier on, is that then to compel you to alter the accounts, the published accounts in some way, or to do something else?
Well, it's set out by them on page 282, better than me paraphrasing it. May I just cast your eye down paragraph 4 onwards on that page? It'll, I hope, give you a sufficient answer, better than I could. Having appreciated they had this power, it's a long sentence, I know, it's the second sentence, having appreciated they had this power, they proposed an undertaking to protect us in the context of the infringement appeal. Could I show you page 285, please? So they say here, as you will see, that as regards documents over which we have a particularised claim to legal professional privilege, the FRC undertakes it will not, without the consent of SDI, such consent not to be unreasonably withheld or delayed, use the documents, provide the documents, but they shall have liberty to apply to the court for an order varying the undertaking set out in the preceding paragraph for any reason. Application preceding paragraph 2 should be given on reasonable notice, save for where they're prevented in law from giving such notice. Now, is there some to and fro around the terms of an undertaking, because the deficiencies in that, which are obvious, were pointed out. And there was then an attempt to find something better, which I don't think has actually resulted in anything definitive being signed. But the point is this, and I don't want to go and overstate the point. You've got expressly on the face of the correspondence a position in which a single case team is looking at SDI qua subject B in the accountancy scheme with a view to using in that investigation the additional documents, the non-privileged material that is responsive to the notice of the 20th of April 2017. Presumably, they would say, the same principle will apply to the privileged material if they get it, if this appeal fails. That is a plain affront to the restriction under SATCAR, which is hitched to the AEP, not the AS. And even if plain affront is overstating it, it is a fact that they say they can use the material gained through one provision for an allied or different or related purpose. That in our submission puts to the sword the concept that there is no prejudice or exposure to adverse use or risk, which is at the origin of this submission. And so for that first reason, ground 2 at least should succeed. I move now, I think, much more shortly to the second basis upon which we say that this ground should succeed if the first and third have failed. And that is by reference to the language of SATCAR. I cannot and do not seek to improve upon the summary of the position on the SATCAR of my Lord Justice Lewison after lunch today. That is exactly the point, that we say that if one's looking for something by way of statutory regime under which the application can, the privilege point can be determined, whilst in the solicitor situation you have something that we've looked at earlier on in the context of Parry Jones. Here, what you've got is Schedule 2, Paragraph 1, Subparagraph 8, that preserves privilege. How in those circumstances can it possibly be right on the most generous interpretation of the decision in Paragraph 32 of Lord Hoffman's speech in Morgan Grenfell, as interpreted by the judge in this case, see Paragraph 84 and following, that it is right to apply it here?
Well, essentially, the steps in the argument, as I understand it, are these. Let it be assumed that the common law is as the judge said it was.
Yes.
Common law is subject to modification by Act of Parliament or validly made statutory instrument. Here there is a part of the statutory instrument that deals with privilege. You don't need to read it in some particularly strained way in order to make it conform with the common law. You just read it and see what it says.
Precisely.
And reading it in a straightforward way, it says we don't have to produce privileged documents. Therefore, it modifies the common law to that extent.
Exactly. But all the other
So the judge got round that by saying it has no relevance here because according to the Morgan Grenfell dictum, there is no infringement of privilege by the disclosure of these documents to the regulator, and therefore paragraph 1.8 isn't it invoked? Although, query whether there's a difference between whether one really can get round the wording of the SACCAR by reliance on what the dictum says.
Yes, what Melody says is of course quite right. The judge came up against, of course, as you've seen from how he puts the matter in paragraph 91 and 92 of his judgment, some difficulty. If one comes on to the top of the last page of the judgment, page 104, and then into 92, I have not found this a straightforward point to resolve. The interpretation of Schedule 2, paragraph 1.8, advanced by counsel for the FRC, involves giving it a much more restricted application than it appears to have on its face. Lord Hoffman's primary reasons, Morgan Renfrew, avoids this difficulty, but if Lord Hoffman's alternative reason represents the law, and I conclude with some hesitation that counsel for the FRC's interpretation is correct.
Well, it avoids the difficulty because there is no privilege.
Precisely. If there's no privilege...
The difficulty there is 8 is talking about somebody entitled to refuse to provide or refuse something in proceedings in the High Court. Nothing to do with the duty to a regulator.
No.
And the Hoffman, as I understand it, exception, and it's most generous, you say, is restricted to disclosure to a regulator.
Right.
But as I said, the regulatory provision isn't related to that. It's related to, I think, any proceedings. It says in proceedings, any proceedings in the High Court.
Yes. Exactly.
Yes, if paragraph 1.8 said you cannot be asked to give documents if to do so would infringe your privilege, then you can see that the Lord Hoffman dictum may enable you to circumvent that by saying, well, there's no infringement. That's not actually how it's worded.
No.
But the submission the judge accepts is at paragraph 91 of his judgment. In 92 he says he accepts counsel for the FRC's interpretation. And that interpretation is that Schedule 2, Paragraph 8 preserves legal professional privilege in circumstances where the infringement, so there is an infringement, was not a technical one. So what he's saying, what the judge is saying, is he accepts the distinction between a technical infringement and a different kind of infringement, but they are both infringements, and Schedule 2, Para 1.8 only applies to the latter class of infringement.
Yes.
But he doesn't seem to derive that from any words in paragraph 1.8 itself.
No. He doesn't. I mean, frankly, the last thing one would ever do is be discourteous. But the reasoning here is thin, and it benefits from a longer, harder look at really what it means. And when one steps back and considers where this leaves us, it leaves us in this, frankly, very unusual circumstance, and that may be to understate it, in which Regulation 1.8, which on the face of it applies to notices issued both under Schedule 1, Regulation 1.1, i.e. against the auditor, and Regulation 1.3, including, most importantly, the public interest entity, i.e. our client, it doesn't remotely mean what it says. And that's not a sound approach in our submission. We submit it's clear, it means what it says, and to read it in any other way is to do a disservice to the plain language of the regulation. Now, unless there's anything else I can deal with on grounds 1, 2 and 3, I'm going to turn lastly to ground 4, which obviously are very different, and I shall take matters appropriately shortly. As my lady asked right at the very start of this appeal, when we weren't dealing with the facts, were we dealing with the matters on this appeal in an abstract? Yes, as I said then, and yes now. So this issue too is being dealt with in the abstract. And you will recall from the judgment in paragraph 20, I don't trouble to turn to it, but just for your reference, that the parties agreed that the court was in a position to resolve 3 issues of principle regarding the claims. The first one being whether legal advice privilege applies to documents purely by virtue of those documents having been attached to emails passing between STI and its subsidiaries and RPC. As to the emails, first of all, then I'll deal as to the attachments. You will have seen from paragraph 30 of the judgment that we referred to the 40 documents in issue as being 19 emails and 21 attachments to those emails. And the premise that everyone was working on was that the 19 emails were privileged, otherwise the issue wouldn't arise. And I said this in terms in the transcript, don't trouble to turn to it just for your note. It's page 1, it's supplemental bundle, tab 10, page 157 at F. As to the attachments, the position is very different. As we stated in our appeal skeleton, paragraph 42, the attachments are not themselves responsive to the criteria in the notice. And there was some discussion below, in front of the learned judge, as to the status of the documents themselves as freestanding, which was nothing to the point that we are now dealing with here. We have a strange situation where you have before you 2 lines of authority, one dealing with copies and one dealing with the billable line of reasoning, and no one is challenging the other version's line of authorities.
Well, the authorities that deal with this question are, I think I'm right in saying, all authorities dealing with litigation.
Yes.
And they are all dealing with disclosure in litigation. And the ambit of disclosure is delimited by what has been pleaded in the underlying proceedings, in the various parties' statements of case. The point you've just made is that what is responsive to the notice is not necessarily what may or may not be relevant to the investigation, but what is responsive to the criteria in the notice.
Correct.
So if one was looking at these attachments separately from the emails to which they are attached, they might or might not be relevant to the investigation. But if they don't independently respond to the criteria in the notice, then they are only in, so to speak, in scope, because they have been attached to the emails.
Exactly.
That's the one.
Exactly.
I was struggling with the point, I think, but just trying to get it clear in my own
Yeah.
mind. I think that's the point.
It is. It is indeed. And once...
Let me see
Sorry.
if I've got it now. So what you're saying is, because you make the point that this exercise is a different exercise from ordinary disclosure, because it is not asking for any independent documents, it is only asking for emails and attachments.
Yes.
But this seems to me to be a slightly different point, which is to say that it's also only asking for documents that meet the criteria that are thrown up by the particular search terms between the dates held by the named custodians. But you're saying that if these documents are regarded independently, then they would not, or some of them at least, would not meet those criteria. Is that, have I understood that?
You have, and none of them would be on their own account.
And do you say
Responsive.
all the emails to which they are attached are covered by LPP?
Yes, they are standard email communications between solicitor and client. And exactly as my lord said, the only reason the attachments are in scope, if I can borrow your language, is because they are attached to emails that are in scope, but which are privileged. And therefore the question, I suppose, can be reduced to this very simple one. Do you treat the communication between lawyer and client as a singular whole, i.e. email plus attachment, or not? If the answer is yes, and the email is privileged, then the FRC are not entitled to these 19 emails and 21 attachments through this notice.
It's astonishing this point hasn't arisen before,
No.
because this must be quite a common occurrence.
We were wondering what the answer might be to that point. And of course, my lord is right, it hasn't.
Well, the answer may be in the drafting of the Rule 10 notice.
Which is the point that my lord made when granting permission.
I didn't mean just in this context. I mean generally in relation to disclosure. There must be plenty of cases where emails are privileged, but there are attachments.
Yes, but I think I wonder whether the answer is that the fact that in most cases the attachment, which will for this purpose not be privileged in and of itself, is a document in the disclosure exercise separately over there. And so what one is never worried about is whether or not a party is going to get the attachment, because it'll be the front page of the Times, to take the learned judge's favoured illustration of the absurdity of my submission as he found it. That the front page of the Times will be a disclosable document if it's relevant in the proceedings, and so no one's fussed whether it's been sent alongside the email. But this is a different situation, not only by reference, as my lord rightly says, to the terms of the SACCAR notice, which are obviously for this case is pivotal. But generally it hasn't arisen, I think, because it's not normally a problem.
But are these, you may prefer not to answer this, in which case that's fine, but you said earlier that 2,000 documents were disclosed as responsive to the notice, and those presumably were a mixture of emails and attachments to emails, which are not, where the question of privilege doesn't arise. But are these attachments documents which have not otherwise been disclosed, i.e. they were not also attachments to non-privileged emails which have all been disclosed?
I'd want to check the actual answer to my lady's question as a matter of fact for responding. Can I just do that, please? I don't know.
You'd say it doesn't matter.
Well,
because even if they're not privileged, then they haven't been asked for.
yes, I was going to say that. Quite such direct terms, I was going to say that. But I would like to find out what the factual position is. So you've asked me a question. I should answer it for you. I'm afraid I can't improve upon my own state of knowledge. We don't know. We haven't done that exercise. It's theoretical. They might be independently responsive, but probably not.
No, I'm not talking about them being independently responsive. I'm talking about them being attached
Yes.
to a non-privileged email,
Yes.
which is responsive.
Yes. Well, in those
Because
circumstances,
what I'm wondering is whether, in a way, SDI have made a rod for their own back, that if they just sent the FRC a whole bunch of emails and attachments, including these attachments, plus a sentence saying, and we've withheld emails that are privileged, no one would ever have known that that some of those documents were attachments to privileged emails. Do you see what I mean? Because they're not privileged in themselves. I suppose some careful person could have gone through every email disclosed and married up all the documents that are attachments, and come across one and said, I can't find an email that this is attached to. It must be one of the privileged ones. But it seems to me that this problem has arisen through a combination, as my Lord Justice Lewison says, of the constrained way in which the notice was drafted, which is different from the usual disclosure exercise in court,
yes.
plus the way that SDI responded to it by not disclosing these attachments so that everybody knows when they are ultimately, or if they are ultimately disclosed, that they were sent to RPC for advice.
But of course they were not, these 21 attachments were not disclosed because they are they don't have a life under this notice, separate from the email to which they attach and of which they form a part of the whole.
Well, unless they were attached to some other email,
Yes.
which has been disclosed.
Yes, but the question is whether they have a freestanding responsive status to the notice, to which I've already said they don't. So they're not independently responsive. The attachments are not independently responsive. They don't meet the 4 criteria.
No, I know, but you're not refusing to disclose them on that basis.
No, we're not. No.
Right.
No. I'm saying so it's unlikely they've been disclosed as freestanding documents.
No, I'm not talking about them being disclosed as freestanding documents. I'm talking about them being disclosed as being attachments
Yes.
to emails which are responsive to the
And
notice,
which are not privileged.
Which are not privileged.
Yes.
Can I just go back to a much more simple point here? You've concentrated on this issue, certainly in discussion on the bench independently, on the importance of the notice.
Yes.
I mean, this turns, however, on the terms of Schedule 218,
Yes.
the application of that. And it says, it doesn't require a person to provide any information or create documents which the person will be entitled to refuse to provide or produce in proceedings in the High Court on the ground of legal professional privilege. So are we driven back to ask you what the position would in fact be in ordinary disclosure proceedings, the disclosure exercise and requirements in a High Court proceedings in these circumstances?
Yes.
So that's why I come back to the point I made. It's obvious hasn't been asked. So if you had an ordinary disclosure, because this then has much wider implications than this regulation. This is this point, it's not been resolved, would affect every disclosure application where you have documents which perhaps can't be obtained elsewhere. They're only in the context of being attached to a document, which is itself privileged. So I'm just trying to understand why it's so significant, the actual wording of the notice. What we really should be concentrating on, putting to you, what we should be concentrating on is actually what would be the position in an ordinary disclosure application in High Court proceedings. How would these be treated?
Yes. My Lord, I think we can answer the question in 2 different ways. The notice is important because of the responsive nature of the duty it triggers. So in other words, the ability to call for and the duty of us to provide, subject to privilege, is limited to the terms of the notice and the way in which it has been drafted. But my Lord's focus is understandably, if I may say so, on a wider point, which we're equally, if I may also say so, interested in, which is the ramifications of this issue being resolved. And if one was looking at this through standard disclosure in High Court proceedings, the position would be, we respectfully submit, uncontroversial, in that the email, which is standard lawyer-client communication, would be privileged. And, because one is looking at the communication so would the attachments with it. It doesn't matter, and this is something that comes out of the CAA case, the judgment delivered yesterday. It may well be that there would be a separate, an original copy of, or version of the document that is the attachment to the email, which may well be responsive, may well be disclosable in civil proceedings.
I understand. But is it in fact, like this test, is it in fact correct that you say it's clear that a document, which in itself, as it were, has nothing to do with advice in itself, it's just a document perhaps containing the front page of the Times, or whatever it might be. I mean, doesn't it all turn on whether that, might it not be said, that might turn upon the whether or not it's intimately tied to advice that's being given in the email. So you'd have to look. It wouldn't just be a global, well, of course, everything attached.
No.
You'd have to see to what extent it's an integral part of advice.
You would, and that's the point that we've made below, and we've made in our skeleton, and we stand by. We're not saying that everything, just because it happens to be attached to a privileged email and forms part of a single communication, has some status bestowed upon it. It has to be connected to the legal advice.
Yes, I see. I hadn't picked that point up.
But if it forms part of the singular communication, you have a communication which is the email and the attachments to the email, and they are regarded not individually. You don't slice up the material. You have, for those purposes, a single communication.
Move away from electronics for the moment and go back to something really old-fashioned. Let us suppose that there is a manuscript. Only one copy of this manuscript exists, and it is sent together with a covering letter to a solicitor for advice. And let's suppose that there's a paperclip that holds the two together, and the manuscript would be relevant to whatever is in issue. You're not suggesting that the manuscript is not disclosable, are you?
No.
Even though it's attached to the only copy is attached to a letter to the solicitor asking for advice.
The only copy.
Well, I'm trying to get
Yes.
away from this idea that, there's another document outside the solicitor's office which is the same document or a copy of the same document, which is obviously easy to envisage with something electronically sent. But if it is a manuscript, so it's not on a word processor, it's not, there's no carbon copy of it, it's just one thing.
Sorry. The answer to my Lord's question would be, as I said before, we would not be saying it would not be disclosable, but what would not be disclosable would be saying it was attached to a letter seeking legal advice.
So the route by which it becomes disclosable is that it's in the power of the client.
Yes.
That's it, to request it back from the solicitor, subject to
Yes.
the deal or whatever it is, and then to disclose it.
Yes.
And then it would be disclosed, listed as one manuscript, and by that you would not be revealing
Correct.
that it had been sent to the solicitor for advice.
Correct.
Right. So let's see where we've got to now. So in ordinary proceedings in the High Court, where there's ordinary disclosure is taking place in the standard way, if the document attached to the email or the letter containing advice is relevant to the proceedings, I hope I've got this correctly, it's not correct to say that just because it is under cover of that it is itself privileged from disclosure.
Correct.
Now, that I understand, and that was my initial feeling. So why is it different here just because it's attached to an email? Why is it different when the statutory test laid down in 1.8 of Schedule 2 is what would happen, what the treatment would be of the information, as it's put, of the information or documents in High Court proceedings? Why is it different?
The difference lies in the fact that as a disclosable document in civil proceedings, the fact of the listing and identification and disclosure of that document would not reveal its attachment, in the general sense of the word, to legal advice given or received. Be a freestanding, non-privileged document that is relevant to an issue in the pleaded case of one party or the other.
But this is not like for like. If you're going to do the analogy with High Court proceedings, surely you'd have to postulate a document which is not relevant to the issues in the proceedings, but is attached to a letter seeking advice from the solicitor, which is relevant but privileged. Because your point is that these attachments are not independently responsive
Correct.
to the notice. So the High Court analogy is they're not relevant to the issues raised on the pleadings. Because if they were relevant to the issues raised on the pleadings, they would be disclosable, just as if they are independently responsive to the criteria in the notice, they would be producible.
Yes, I was addressing a different point. As I may have misunderstood, I was taking it away from the confines of the notice here. Of course, my lord is quite right. Of course you are. That if one is drawing a parallel between supposed High Court proceedings and the position here, it's exactly as you put it, and you have our argument precisely. I was answering a different point, I'm sorry.
But on that basis, is this right? And this may be going back to the initial start of the discussion with Lord Justice Lewison. Is this right? Your case is not that these documents don't have to be disclosed because they're privileged. It's because they're not responsive to the notice, which is a completely separate point.
Well,
I thought your case was there. I thought your case started, but I may have completely misread everything, as saying, well, these are attached to a privileged document, therefore the exemption applies. You're now, if this is right, making a completely different point, which is to say we're not concerned with privilege here at all. It's just that these documents don't respond to the criteria.
no.
Notice.
No.
Have I got that completely wrong?
It must be me, with the greatest possible respect, but I take the blame. I think what my lord said is not quite right. Can I just restate our position?
Yeah.
We say that there is a difference in law in how one treats a communication and a document. In the context of the notice in this case, the notice calls for us to produce, as the notice puts it, all emails and attachments to emails in the possession and control of SDI satisfying 4 criteria. The emails are treated for the purposes of this hearing as privileged and responsive. The attachments are not responsive in and of themselves, but under the notice and the way it's been drafted, the only reason that the attachments are brought into the equation at all is by reason of their attachment to a potentially responsive but privileged email.
So your point essentially is, either you treat the email and the attachment as a single communication,
Yes,
in which case the communication is privileged,
correct?
or you treat the email and the attachment as separate, in which case the email is responsive but privileged, and the attachment is not responsive.
Exactly. Exactly. Yeah. So it's exactly the same as behind what my lord has just said.
But what I'm not quite sure about is when you say that they are not responsive, you mean that if the notice had said emails and attachments or any other documents that are thrown up by these 4 criteria, these would not be within the category of documents thrown up by these criteria?
Well, no, it's simpler than that. It is just that the documents don't meet the criteria in sub A to D of the FRC notice.
Is that fact recorded in the judgment? Because I hadn't understood that to be the case before.
It is in our skeleton argument, paragraph 42, which has not been challenged, although my learned friends make a complaint about the lack.
Which of your
Sorry, the appeal skeleton. So sorry. In paragraphs 42 on page 17 in the internal numbering. And in the middle of that paragraph there is you see the highlight of the word attachment.
For the avoidance of doubt.
Yes, exactly. 42.
So essentially the point is that the judge's discussion of all the cases relating to pre-existing documents, on your case beside the point,
Correct.
because the premise is that all those underlying documents are relevant to the issues in action
Correct.
and don't exempt themselves from disclosure simply because they're sent to lawyers.
Agreed.
Here, you say, the scope of required disclosure is the criteria in the notice, and these attachments viewed independently are not within those criteria.
Correct.
If on the other hand they are to be regarded as part of the email which is in the criteria, then that's a single communication.
Exactly so. Exactly. And those are our submissions. Now, I haven't dealt with the CAA case. Would you like me to do that now, or would you like me to do that tomorrow in a reply, or what would be most convenient?
Doesn't it, the way you've
Yes.
been putting the case?
Yes.
Because
If you treat the emails and attachments as separate documents, which is what the CAA case says, then the attachments don't respond to the criteria.
Correct.
well, I thought you said the CAA case doesn't say that.
No, the CAA case. Sorry, unless I wasn't listening carefully enough. The CAA case chimes with and is consistent with what we're saying, in that it says 2 things. One, it says that you treat an email and attachment as a single communication. But 2, separately from that, and it's a separate point, from the point of view of disclosure, the documents, if they are relevant / responsive, then they fall to be disclosed out with their status as an attachment to an email that is privileged.
Have you got copies of them?
Yes, it's in the supplemental authorities bundle. And it's behind divider number 4.
It's only a few paragraphs, isn't
Well,
it?
it is, my lady, but it is helpful, I think, for you to know a little bit more about it than that, because it rather explains the paragraphs. May I?
Yes.
If I don't take long, what time would you like to?
Well, certainly don't write yet, but 4:15 certainly.
I'll be done long before that, I hope, unless I make a muddle of it. Can I invite you, first of all, to what the case was about? The case is factually a little bit involved, But it suffices, I think, to say this. The CAA were ordered by Mr Justice Morris at first instance to disclose certain materials over which they claimed privilege, and they comprised emails and attachments. They said, can we schedule them and provide some evidence explaining of what it comprises? Paragraph 26 in Lord Justice Higginbotham's judgment explains that the CAA was directed to provide a more detailed statement in relation to privilege, identifying separately each email and each attachment over which privilege was claimed, and explaining which documents it considered would be privileged under the December 2018 judgment, and which would not be privileged under the judgment, but over which the CAA still claimed privilege, and why. And then if one goes on to paragraph 33, ground 3 of the appeal with which this point is concerned, was he the learned judge, erred in holding that an assessment of whether an email and any attachment must be carried out discreetly and without reference to any attachment or covering email, respectively. So that was the task, which was said to be a little artificial by the appellants. Then we come on to paragraph 104, which is the passage that my lady has in mind as being what really matters in the end. First point to note about this, for what it's worth, is that this is all, of course, obiter, as is perfectly obvious from the consideration of the point. It didn't feature heavily before us, paragraph 106, and I do not consider it raises any point of principle, nor does it appear to bear upon whether any of the relevant documents in this case are privileged or not. I can deal with it shortly. And then paragraph 107 is useful and can be unpacked. It is well established that a document which is not privileged does not become so simply because it is sent to lawyers, even as part of a request for legal advice. Venturius and Immerman, we agree. In giving disclosure, some separate consideration of substantive documents and attachments therefore has to be undertaken. Agree. Whilst an email and attachment can be regarded as a single communication, we agree, separate consideration will need to be given to the attachment, given that it will have been received or created by the sender, and therefore may require discrete consideration. Agree. And so we submit that there are 2 points to be derived from this, which are consistent with our submissions. One, obviously, an email and attachment can be regarded as a single communication. So one is privileged, the other goes with it. And two, separate consideration will need to be given to the attachment.
So that's a will, not a may.
Yes, sorry.
You have to give separate consideration to the attachment.
Yes, separate consideration will need to be given to the attachment, given that it will have been received or created by the sender and therefore may require discrete consideration. You have to consider it, and may require discrete consideration. So, in this very recent...
But if when you consider it, you think it is not covered by privilege, then you have to disclose it. Is that what you say?
Yes.
But you say you're disclosing it then as a freestanding relevant document.
Exactly.
Right.
Exactly.
But going back to the point my Lord Justice Lewison was making, if you consider it and you think, well, it's not privileged, but it's also not relevant, then you wouldn't disclose it, but that would be on the basis not of privilege, but on the basis of lack of relevance.
That's right. I mean, reduced to it's essential. There's a two-stage process. You analyse an email and attachment as a single communication, which here we say equals privileged. Two, then you analyse the attachment separately for standard disclosure, and if it is relevant, then you disclose it, and if it isn't, you don't. First is a question of privilege, the second is a question of relevance.
Anyway, so we've now got to, maybe you started with this, but you've certainly got to a clear position now. You accept that ordinarily you look at the two separately. If the attachment if the attachment would otherwise be relevant but not privileged, it's disclosed. If the attachment looked at on its own is irrelevant, it doesn't go in.
Correct.
And you say that if you apply that direct analogy, as it were, to this case, you take the document separately, the attachment. If it doesn't respond to the criteria, which is the touchstone of relevance in this context, then you don't disclose it. Because
Yes.
it's not relevant. That's the equivalent of relevance.
Yes, it's not
So
within
that's it. That's your kind of composite submission.
subject to the overriding point, prior point of the single communication.
Yes, but you don't. Oh. I think that's a complication. Why do you? I mean, I find that on this analysis a complication. What is it that will be covered and answered by the single communication point that's not covered by the relevance or non-relevance point? Are you postulating now something which is relevant, which does respond to the criteria? I thought none of these did respond to the criteria.
No, I'm sorry, I'm obviously making a fist of this, so I apologise. Can I just have one last go at stating our position, I hope, with that complete accuracy? There is a two-stage process we submit in play here. Stage one, this is a matter of generality. Leave the notice for 1 second. Generality. Stage one, you have an email and an attachment.
Yeah.
That constitutes in law a single communication. Email, for these purposes, is deemed to be privileged. Attachment privileged. A single communication, it's a no-go area. Stage two, then you look at, and this is from the point of view of standard disclosure conduct, you look at the document, the attachment, as a separate, freestanding document. And you ask yourself, is this relevant to an issue pleaded in the case? If yes, disclose. If not, don't disclose. Now, hitched to the notice of the 20th of April, you have a narrower tableau. You have a situation in which you've got 4 defined criteria, and the document must tick it all, against which to measure this.
Yeah.
Plus also, you have the language of 1, which is all emails and attachments to emails. So there is actually, as it happens on the wording of the construction of the document, there is no separate life given to the attachments. It is their attachments qua with email rather than anything else. So in our submission, the position is, as I hope I'm not overstating, as clear as that. 2 stages, privileged.
Right, but on your argument, even if these attachments were separately of themselves responsive to the criteria, you would say they still are not to be disclosed because they are attachments to emails which are privileged and they're a single communication, and because the ambit of what's asked for is narrower than in the High Court disclosure exercise, you don't do that second stage of separate consideration as to whether they're responsive or not, because that's irrelevant given that they're part of a privileged communication.
Yes.
Is that right?
Yes, it is correct. If you are with me on my interpretation of what the notice calls for, if the court was to construe the notice as saying, don't be silly, Mr. Lissac, what it means is, it means emails and it means attachments. If we have attachments that are responsive, they obviously would be disclosed straight away. But it's on the interpretation of what this means, not so as to be difficult or stand on dance on the head of a pin.
Well, I
But-
think strictly speaking, that's not an issue, is it, before us?
No, it isn't.
What it means?
No, it isn't. It isn't, thankfully. It's an interesting litmus test for the whole exercise.
Yeah, I was
Well, I
thinking
mean,
one possible litmus test is what would you put in the section of the disclosure statement which deals with privileged materials? Normally you just say, various communications with my lawyers. Would you have to list the attachments separately if they were, as it were, disclosable as freestanding attachments? I would think probably not.
I agree with you. I agree.
Can I just put the contrary case to you on your analysis? Because your analysis depends, and I don't know what, as I said, Mr Lesat's going to say about this, but I'll just put it anyway. I mean, it's leaving aside the single communication point, which I think is a difficult issue, bearing in mind the analysis in the civil aviation case. But leaving that aside, the privilege because it's all one communication, leaving that aside. Your analysis depends upon the relevance, the equivalent of the relevance being responding to the criteria. But it could be said that the relevance is what is required, that is everything which is attached to an email which which satisfied one or more of the criteria. In other words, it's not just that each document has to, but that the email responds to the criteria. Then there has to be disclosed all the attachments to it. And then if you look at each of those attachments, they're relevant because they satisfy that requirement. In other words, you're presupposing that the criteria, each of the 4 points, is required for all the documents, but what I'm querying is whether that's in fact correct. And so if you translate that into ordinary High Court proceedings, it would be a case where actually the attachments are relevant. That's the contrary argument.
I understand the contrary argument, and I have no difficulty with it so long as the privilege is preserved. I don't want to go back around the houses again. Now, I realise my Lord is putting to me the contrary position.
Yeah.
It's not how...
The privilege is preserved from your perspective because the emails don't have to be disclosed, and they're the things that contain the advice.
Yes.
The attachments don't contain the advice. Now, you may say, well, they're not going to get much out of them because they don't respond to the criteria, but they've asked for them. And in that sense...
Well, certainly,
they want them.
as my Lord has said, that and as my lady before said, insofar as the attachments are individually, separately responsive, if that is the concluded view, they will be disclosed subject to privilege. But that doesn't actually affect the question that arises here in our respective position in respect of ground 4, which is essentially one as to whether you treat the communication and the document separately.
But there may well have been amongst the many documents you did disclose, which are not privileged, attachments which were not of themselves responsive to the 4 criteria. But you disclosed those, presumably consistent with your view that they're all a single communication. Is that right?
I would strongly suspect that's correct, but can I take advantage of the time to check that overnight and come back tomorrow morning?
Right. Well, thank you. So those are your submissions.
They are.
So thank you very much.
Thank you.
Well, normally we carry on a little bit, but I think if it's only 4:12, we can give you a respite overnight and start again at 10:30. I assume, Mr. Lesat, you'll be finished well in time tomorrow.
Yes, sir.
Yes, well, that's very good. Thank you very much. And 10:30.
Mr. Lesak's up again tomorrow. Seriously, 2 days.
I know. I'll never agree with myself.